In writing the U.S. Constitution, the founders made good on their commitment in the Declaration of Independence to create a government in which we, the people, are governed by a system of laws, rather than the whims of our political leaders. The signers of the Constitution thought deeply about the kind of country they wanted to build, and the kind of country they did not want to build. The Constitution reflects their belief in the rule of law, that a system of laws could protect individual rights and liberties and prevent any one person or branch of government from becoming too powerful. John Adams believed that the best government was one of laws, not men. In fact, the purpose of the rule of law is to constrain the people who serve in powerful positions at all levels of our government and society, and to prevent any one person or branch of government from gaining total authority. In this course, we will examine the judicial system's place in our constitutional republic, its role in protecting the rule of law, and its responsibilities as the third branch of our government. The rule of law is a concept that judges talk and think about often, because it is their job to interpret and apply the laws of our country. In this course, we use the law as an umbrella term that includes all the rules, treaties, statutes, acts, ordinances, laws, regulations, and legislation that are created by a legislative body like Congress and carried out and enforced by an executive body like the President's administration. All the laws created in our country must fit within the framework set out by our Constitution, which is the supreme law of the land and the ultimate source of our law. In other words, no law, state, federal, or local, can restrict or conflict with rights delineated by the U.S. Constitution. U.S. Supreme Court Justice Hugo Black once wrote, "The United States is entirely a creature of the Constitution. Its power and authority have no other source. And the source of the Constitution's power comes from we the people." We, in this sense, is a big word. We are a big country, and we are tremendously diverse. From the very beginning, our political discourse has been characterized by sometimes vehement disagreement and frustrating compromises. We the people have always had disagreements, and probably will continue to disagree, about what the law should be, and the meaning and impact of the laws we have. Although it shapes nearly every aspect of our domestic law, the Constitution, even with its 27 amendments, is only about 7,500 words. It is both the oldest and one of the shortest constitutions in the world. As such, it provides more of a general outline than a detailed blueprint of government. The first three articles spell out the three main branches of the U.S. federal government. Article 1 outlines the role, structure, and process for electing the legislative branch, or Congress. Article 2 outlines the process for electing a president and the role of the executive branch. And finally, Article 3 outlines the judicial branch and the Supreme Court of the United States. This three-part or tripartite system of government was designed to distribute power among the three branches of government to prevent any single ruler from gaining too much power. Each branch has abilities to check the other two branches and maintain a balance of power. For instance, Congress is the legislative branch and is responsible for enacting laws and funding the government. Congress also can confirm or reject presidential nominees to judgeships and to senior agency positions within the executive branch. In exceptional circumstances, Congress can also impeach and remove the president, judges and justices, and agency officials. The president heads the executive branch, which carries out and enforces laws. The president can veto legislation created by Congress and nominates heads of federal agencies and federal judges. Federal judges and Supreme Court justices are nominated by the President and confirmed by the Senate. The Supreme Court can overturn laws it deems unconstitutional. The judiciary's ability to determine whether actions taken by the executive or legislative branches are constitutional is known as the power of judicial review. This power was not written into the Constitution. The founders had discussed the idea of judicial review when debating the Constitution, but it wasn't firmly incorporated into the American legal tradition until Chief Justice John Marshall's landmark 1803 opinion in Marbury v. Madison. After losing the election of 1800 to Thomas Jefferson, outgoing President John Adams worked with Congress to quickly pass the Judiciary Act of 1801, which created new courts and judgeships filled with President Adams' preferred candidates. One of them was William Marbury, who was appointed to serve as a Justice of the Peace. But the incoming administration's new Secretary of State, James Madison, refused to deliver Marbury's commission, the document he needed to officially take his job as a justice. After all, Madison thought, the Judiciary Act was an obvious power play by a defeated candidate. Marbury petitioned the Supreme Court to force Madison to deliver his commission. The Supreme Court agreed that Madison's refusal to deliver the commission was illegal. But it also found the law that allowed Marbury to sue in the first place was itself unconstitutional, because it extended the Supreme Court's authority beyond the powers specified by Article 3 of the Constitution. A law repugnant to the Constitution is void, Marshall wrote. It is emphatically the province and duty of the Judicial Department to say what the law is. With these words, the Supreme Court, for the first time, declared unconstitutional a law passed by Congress and signed by the President. Nothing in the Constitution gave the court this specific power. But the decision cemented the Supreme Court's role as a co-equal branch of government and created a bedrock judicial principle that stands to this day. Like judicial review, many features of our judicial system were not written in the Constitution. Instead, they were established over time. Article 3, which creates the judicial branch, is just 377 words in the Constitution, far shorter and much less specific than Article 1, which sets out the power of the legislative branch, and Article 2 about the executive branch. Article 3, Section 1 of the U.S. Constitution begins, "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish." It further says judges shall hold their offices during good behavior, that judges' salaries cannot be reduced while they are in office, that the jurisdiction of the federal courts extends to cases arising under the Constitution, U.S. law, and treaties. It also guarantees trial by jury for all crimes except in cases of impeachment and defines treason. And that's it. Article 3 says nothing of how courts will operate, the specific responsibilities judges will have, or how they should do their job. This means the structure of our courts and our expectations for the judicial role have been established through other means, such as political processes, traditions, case law, and precedents that have evolved over hundreds of years. It also means there is a lot of flexibility in how and even where our courts operate. For instance, the U.S. Supreme Court building wasn't built until 1935. So over the court's first 146 years, it met in a building in New York City, at City Hall and Independence Hall in Philadelphia, in various rooms within the U.S. Capitol building, and for a time after the War of 1812, in a private home in Washington, D.C. Today, courts might conduct sessions in a courthouse, at a law school, or in some circumstances, via video conference. The role and responsibilities of judges have also changed over time. Judicial responsibilities may be handled by a single judge or might be shared among other judicial officers, such as magistrate judges or special masters. If a case is being heard en banc, which generally means the case is reviewed a second time by all the judges of a particular appellate court, the court may even have a panel of 15 or more judges. Since the first Judiciary Act was passed by Congress in 1789, Congress has changed the number of justices on the Supreme Court 6 times, and the composition of lower courts has changed many more times. The Constitution does spell out which cases must be heard in federal court. Federal courts have limited jurisdiction, meaning they can only hear certain types of cases that arise under the Constitution, federal laws, and treaties. Those include admiralty cases, cases between citizens of different states, and cases between citizens of a state and a foreign state or its citizens. The Constitution only addresses federal courts. Each state has its own court system, designed by its state constitution. State courts are courts of general jurisdiction, meaning that they hear all the cases that aren't required by the Constitution to be heard in federal court. For this reason, 90 to 95% of all court cases in our country, including criminal and civil cases, are handled in state courts. In certain circumstances, the U.S. Supreme Court may hear a case that has been heard by a state Supreme or Appellate Court. There are many differences between state and federal courts, and among the court systems throughout the states. But there are also many similarities, especially when it comes to the big picture tasks of interpreting and upholding the law, protecting rights and liberties, and resolving disputes quickly and efficiently. Let's examine a few key features that are common to both state and federal courts. First, courts decide disputes arising under the law. Courts are tasked with resolving cases. In fact, a U.S. court can only act or exercise judicial authority when a case is brought before it, either by the government acting to enforce the law, or by a person or entity who believes they have been wronged by someone who has violated the law. Black's Law Dictionary, the leading legal dictionary in the United States, defines a case as a civil or criminal proceeding, action, suit, or controversy at law or in equity. Cases must involve real disputes between parties, not hypotheticals. This is known as the case and controversy requirement, and it is designed to help keep courts out of policy and political matters that are the domain of the elected branches. Courts almost never offer opinions or speak out on political issues and controversies outside of written opinions in actual cases. There are 2 general types of cases. Criminal cases involve a violation of the law and might range from misdemeanor shoplifting to serious felony cases, such as homicide, drug conspiracies, and violent assaults. In criminal cases, courts determine whether a person committed a crime and what the punishment should be. Civil cases are private disputes between 2 or more parties and might involve things like the interpretation of contracts, liability for personal injury, and disputes over property boundaries. Civil cases generally begin with someone filing a lawsuit against someone else in order to obtain a court order or a financial judgment. Some cases, like traffic infractions, can involve civil and criminal penalties. Second, both state and federal courts rely on the adversarial system for handling cases. In the adversarial system, each case has a claimant, the person or entity who brings the case, and a defendant, the person or entity who is accused of wrongdoing. In criminal cases, the case is brought by the government. Both parties are able to argue their case before a neutral fact finder, either a judge or a jury of peers, who will decide whether the defendant is guilty or innocent. This adversarial system comes from the English common law tradition, which developed over hundreds of years as cases were decided by courts and precedents were created. In the common law tradition, the clash of adversaries before the court is seen as the fairest way to resolve a case, because the parties involved have the most at stake and are in the best position to argue their case. The third feature that is common among our federal and state courts is structure. The federal and state judiciaries generally follow a three-tier structure, with trial courts, which determine the facts of a case, courts of intermediate appeal, and a court of last resort, usually a Supreme Court, which has the final word. Some states may only allow one opportunity for an appeal, but the multi-tiered structure of courts affords litigants the opportunity to have the work of the lower court reviewed. Appeals do not guarantee a correct result or perfect process, but they do allow for clarification when lower courts disagree and for the correction of errors that substantially affect the fairness of the process. Finally, all courts play a fundamental role in upholding the rule of law. Remember, the founders created a government in which we, the people, would be governed by laws, rather than the whims of political leaders. The rule of law is a principle under which all people, institutions, and entities are accountable to laws that are publicly developed and enacted, equally enforced, applied and interpreted by an independent judiciary, and consistent with international human rights principles. Every branch of our government plays a role in upholding the rule of law. The judiciary has a particular responsibility to act as the intermediary of the people in interpreting and applying the law. In doing so, judges ensure that the political branches of government never exceed the authority granted to them in the Constitution by we the people, and that the laws of our nation never infringe upon our constitutionally guaranteed rights and liberties. As U.S. Supreme Court Justice Felix Frankfurter wrote in a 1947 opinion, "There can be no free society without law administered through an independent judiciary. If one man can be allowed to determine for himself what is law, every man can. That means first chaos, then tyranny."